Good morning, everybody, and a very warm welcome from me, Mervyn Vermeulen, to all of you attending the Family Law Roundup December 2024 edition. I'm coming to you all the way from the South Coast, looking like a lobster and answering the age-old question of who reads case law on their holiday, and that's clearly this guy. So judgment aside, let's get into it. It's great to have all of you here today. I am sitting outside in a very uncontrolled environment, so please do forgive me if there is some ambient noise or screaming or shouting or waves, but this view is not to be traded for anything, and I hope and trust that you guys will understand. So, folks, as we get into the Family Law Roundup for December 2024, being our very first roundup this year, I'd like those of you following along on computers just to check out the following link. I'm posting it in the chat. It is not included in the roundup this month, but I am going to be looking at it a little bit later. That is a case that is making the rounds at the moment, Mavundla versus NEC, and causing quite a stir in the conversation regarding artificial intelligence. So we'll look at that a little bit later for those of you who'd like to go to SAFLI so long. Right, as we get started, as those of you who are veterans of the Roundup know, ThinkLegal is all about legal knowledge open to everyone. We've been doing this since 2020, and we are loving every moment of it. And thank you for making it possible for us to run this initiative. For those of you interested in registering for events, joining WhatsApp groups, purchasing resources, or viewing past webinars, please do go to www.thinklegal.co.za and enjoy some of the resources available on that platform. Right, so for those of you who are that way inclined, you are more than welcome to purchase the course pack by going to the link which I'm posting in the chat right now. This is an optional bundle of resources. It contains 17 judgments. It contains our summaries. And for those of you who are affiliated with SAM or social justice, you will get 2 CPD points for attending the webinar today and purchasing the bundle of resources. Rest assured, however, for those of you who are not inclined or not able to purchase the resources, you are still most welcome to attend this free presentation, and I hope that it will assist you in hitting the ground running in your family law practice. Here are some save the dates, folks. I've plotted out all of our family law roundups for the year, so please, for those of you who would like to attend all of our family law roundups, please do screenshot the screen now, as you will find all of our dates and times for family law roundups. The next one, very importantly, where we're going to be looking at all of the developments in January 2025, will take place on the 7th of February. Then, folks, please do save the date for some of our paid CPD trainings. We currently have 3 SAM CPD trainings that we present. The first is the Children's Act Deep Dive, which we've been presenting for the last 2 years or so, or 2 or 3 years. We keep updating it, obviously, as things happen. That is a 2-evening training, February 12 and 13. From 5:30 to 8, you get 5 SAM CPDs, and consultant is currently busy with the SACSSP application, and we will let you know once we have the outcome of that. Children's Act Deep Dive, 850 Rand to attend. Drafting for Divorce, April 9 and 10, a 2-evening course, also 5 CPDs, also 850. And then finally, Divorce 101, 3, 4, and 5 June 2025, from 5:30 until 8 every evening, 6 SAM CPD points, and that is 850. Or if you would like to get yourself set up for CPDs for the rest of the year, you can attend all 3 for 2,200 Rand, which is a significant saving. Go to thinklegal.co.za, go to our events page, and you can register for these events. Right. Now, before I go into our upcoming free events, I want to alert all of you to the very interesting judgment of Mavundla versus MEC, Department of Cooperative Government and Traditional Affairs, KwaZulu-Natal, and others. Your citation on the screen there. This is a matter relating to the use of artificial intelligence in formulating a notice of appeal in that stage and or heads of argument, but it is obviously relevant to all of us, the judge having some serious things to say about the use of artificial intelligence by lawyers. Please do have a look at that case, and that then takes us to our free upcoming events. As a result of this, we have decided to chime in on the debate surrounding artificial intelligence. We are doing a webinar called AI Literacy, a Legal Perspective on 28 February 2025. For those of you who would like to register, you can go to StreamYard and register by following the link which I am pasting. It will be up on our ThinkLegal website, probably in the next day or two, certainly by Monday. And then another free event on the 17th of January, we have Agile Assertiveness Workshop for Lawyers and Mediators, guest presented by Mr. Louis Nagrini, who is an executive coach. I have attended personally this training on several occasions, and I can tell you that it certainly is well worth your while. Louis is a very entertaining and insightful presenter, and we're thrilled to have him on the platform. So, finally, before we get into the roundup, thank you so much for those guys who are supporting us from Lawbox, practice management software by lawyers for lawyers. Try it free for 14 days, lawbox.co.za. And then finally, patience from all of my friends and colleagues at Vermeulen Attorneys with our beautiful Belito background. Just to share with all of you that we are finally opening our doors to our North Coast branch on the 1st of February 2025. So, without further ado, let's head into the roundup for today. Please keep an eye on your screens. I am going to be running a little ticker at the bottom with the bundle pages and the summary pages for those following along. First off, friends and colleagues, we start off with the topic of divorce, and we will be discussing the matter of STH versus ATH, and this is a judgment coming from the Pretoria High Court on 28 November 2024. It is under the pen of Moshuana J, and you can find it in your bundle on page 1 and your summary on page 1. The matter deals primarily with spousal maintenance. In this instance, the plaintiff, the wife, instituted divorce against the defendant and sought lifelong spousal maintenance after the irretrievable breakdown of a 25-year marriage. She claimed 28,000 Rand per month and medical aid contributions. The defendant opposed the claim, the husband, arguing that the plaintiff could sustain herself. Obviously, the court analyzed both parties' financial positions and the evidence of need under Section 7.2. Now, what was interesting in this judgment and the aspects covered, obviously a good exposition of Section 7.2 of the Divorce Act being our checklist for spousal maintenance. Then the Moog versus Moog principles on automatic entitled to spousal maintenance. And then obviously the court referenced EH versus SH, that maintenance orders must be just and consider various factors. The claimant spouse bears the onus to prove a need for maintenance. The clean break principle was also discussed in paragraph 1 and just restated by the court. In this matter, a decree of divorce was granted and the claim for spousal maintenance was dismissed, with each party paying their own costs. Our notable quotes in this paragraph or in this judgment come from our references to our other cases. Paragraph 27, Moshuana J stating, in EH versus SH, the SCA held that a person claiming maintenance must establish a need to be supported by the other spouse. Should the need not be proven, it would not be just for a maintenance order to be made. On the strength of this authority, it must follow axiomatically that the claimant, in this instance, the plaintiff, bears the onus to show the need. And the court here obviously restating what we've known for a while, that spousal maintenance is not just for the asking. You need to first establish, or you must first establish a need. Then at paragraph 31, the court quoting from Mo going on into paragraph 32, Mo continued to expressly and insightfully state the following: spousal support orders remain essentially a function of the evidence led in each particular case. In some cases, such evidence might come in the form of highly specific expert evidence, which enables parties to present accurate pictures of the economic consequences of marriage breakdown in their particular circumstances, close quote. And the court then says it must be so that the onus lies on the claimant to adduce evidence in support of the claim for spousal maintenance. In other words, the claimant must establish the need and must adduce sufficient evidence to enable the court to make a judgment. That was MM versus SMT and another Safley reference, ZAGPPHC 1237. And sorry, that was, apologies, STH versus ATH. Got our line error out of the way very early in the roundup today. STH versus ATH, Safley reference, ZAGPPHC 1237, Mushwana J, North Gauteng High Court. Next up, folks, we go into the realms of procedure with now MM versus SMT and another, and that is ZAGPPHC 1263, and that is under the pen of Van der Schuyf J. For those of you following along, you can find it in your bundle at page 17 and your summary at page 2. The matter of MM versus SMT is essentially a cautionary tale, folks, and the court took it upon itself to really articulate the cautionary tale here of approaching various forums during the course of divorce proceedings. And now, what had happened here was that the parties were divorced by the regional court in 2023. The applicant then sought a declaratory order that an interim order granted back in 2021 during the course of the divorce has lapsed and is no longer binding between the parties. Now, there were various aspects covered in this judgment, folks. One of the aspects covered was the appointment of a curatrix ad litem who was appointed for the minor child in terms of this interim order. The court obviously enunciating the difficulties occasioned by approaching different courts during divorce proceedings. And then the court essentially made the point that interim orders in these divorce proceedings had lapsed when they were superseded by the final divorce order, which in this instance incorporated a settlement agreement. What was interesting in this judgment, folks, is that the parties were ordered to go to mediation. However, this was in terms of the provisions of the parenting plan. So the parties in their divorce settlement had agreed to refer any disputes to mediation. The court per van der Scope J in this matter said, look, your settlement agreement makes provision for mediation. It has been made an order of court. Now go and mediate. The declaratory order obviously granted, the court finding that the interim orders had lapsed simultaneously with the decree of divorce being granted by the regional court in 2023. The notable quotes are first off paragraph 13, and then one of the additional orders which the court granted, which I found very interesting. Paragraph 13 reads as follows. This court is, however, not stepping into the shoes of the mediator, where both parties agreed that the issues pertaining to the minor child's well-being and care should be referred to mediation. This court is only concerned with issuing a declarator regarding the status of the interim order granted on 9 August 2021. Additional Order 1, folks, reads very, very interestingly. The issue regarding the enrollment of the minor child in so-and-so primary school, if it remains unresolved, is to be referred to mediation in terms of the agreement reached by the parties and captured in the parenting plan attached to the settlement agreement, made an order of court with the granting of the decree of divorce. A very, very interesting judgment where the court pins its colors to the mast and says to the parties, or takes that step to say to the parties, go and mediate. And I'm ordering you to go and mediate. Now, folks, just remember, this does not mean that the court now has the authority to simply order parties to go and mediate. Remember that this was a provision in the settlement agreement which was signed by the parties, or at least in the parenting plan attached to the settlement agreement. So it was already made an order of court by consent previously. The court not ordering the parties to mediate insofar as saying, adhere to your agreement, which was already made an order of court. This was MM versus SMT and another. This was from the Pretoria High Court per van der Scope J. And that leads us on to our next judgment, WB versus JJB. Very interesting judgment per Haupt AJ. It is a leave to appeal judgment. And our SAFLI reference, folks, on this is ZAGPPHC 1312. For those following along, you can find it in the bundle on page 22 and summary page 3. Now, this is a leave to appeal, an order made by the court pursuant to a settlement agreement signed between the parties, which was considered by the court in the unopposed divorce court. The defendant, who was the husband, applied for leave to appeal against the divorce order, which was granted on the 4th of November 2024. The order incorporated a settlement agreement relating to minor children, maintenance, and other issues. And in this instance, the court exercised its discretion to amend certain clauses which the court deemed to be in the best interests of the children. Now, folks, as you are aware, usually in unopposed divorce court, only one of the parties would be present. So in this instance, the husband was not present in court when these changes were effected to the settlement agreement by the court. The husband, obviously aggrieved by this, applied for leave to appeal the order. In this judgment, the court deals with Section 117(1)(a) of the Superior Courts Act, obviously the principles relating to leave to appeal. It looked at Section 6 of the Divorce Act, obviously requiring adequate provisions to be made for minor and dependent children when a divorce is granted. The best interest of the child principle enunciated in Section 9 of the Children's Act, and then the judgment of ZDE versus CE on the High Court's duty to interrogate facts and arrangements made in settlement agreements insofar as it relates to the best interests of children. And then it deals very interestingly with one of our talking points on our WhatsApp groups, which is the deferment of maintenance to the maintenance court, those clauses where the parties say, we're not dealing with maintenance now, we will refer maintenance to the maintenance court to adjudicate. In this instance, the leave to appeal application was dismissed. Leave to appeal was therefore refused and no order was made as to costs. Notable quotes, paragraph 10, 11, and 20. Paragraph 10 saying, it is settled law that the High Court sitting as upper guardian is not a mere rubber stamp where the interests of minor children are involved and the parties have reached a settlement agreement. When establishing the best interests of minor children, the court as upper guardian has a wide and unfettered discretion. The SCA and ZDE versus CE confirmed the duty of the High Court as upper guardian to interrogate the facts and arrangements made in settlement agreements insofar as it relates to the best interests of the child involved, and that the court is not bound to follow the recommendations of the family advocate and retains its own discretion. Then paragraph 20 states that the Divorce Act does not provide the court with the discretion to ignore the evidence provided and simply grant a decree of divorce and defer outstanding maintenance issues for determination to the maintenance court. Such an approach would be a dereliction of the court's duties as upper guardian and in terms of the Divorce Act. I think a judgment warranting interesting discussions on the court's powers to interfere in a settlement agreement entered between the parties, particularly where the one party is not present in court. That was WB versus JJB, leave to appeal judgment by Haupt AJ in the North Gauteng High Court. Next up, folks, we are going to DJMF and another versus LF and others, ZAGPPHC 1315. This judgment landed on the 11th of December 2024 and flows from the pen of Mbongwe J. Our SAFLI citation, as I mentioned, ZAGPPHC 1315, and you can find it on bundle page 31 and summary page 4. This matter deals with procedure and specifically a separation of issues which was sought in terms of Rule 33.4. Now, for those of you who have been following the roundup, you will know we've had some very interesting and very conflicting judgments. Even the birds flying overhead here agree. Some conflicting and interesting judgments on the issue of Rule 33.4 and separation of issues in divorce. In this instance, the applicant, who was the first defendant in a pending divorce, applied in terms of Rule 33.4 for a separation of issues, seeking to have the decree of divorce and the question of primary care and residence of the minor children determined first, postponing maintenance and accrual, which included several trust-related claims for adjudication at a later stage. The court looked at the Rule 33.4 grounds for separation of issues. It looked at Ralph versus Standard Bank Properties, principles on separation of issues. It looked at the issue of convenience and potential curtailment of proceedings or reduction of costs. And the principle discussed then that courts will not grant a separation purely on the basis of saving time and costs, particularly if the issues are interlinked and a staggered hearing could be more costly. The party seeking a separation should not be the cause of any impediment to the finalization of the dispute, and where accrual and trust assets are alleged to have been commingled or disguised, the court may require a single hearing of evidence to determine the true nature and extent of the party's assets. This another one in our line of cases where separation was refused. A recent one also emanating from Pretoria, where separation was refused, which you can find in one of our previous roundups for last year. Application dismissed with costs on the party and party scale C, including costs of senior counsel. Paragraph 9 of the judgment, notable quote stating the entitlement to seek the separation of issues was created in the court rule so that an alleged lacuna in the plaintiff's case or an answer to the case can be tested, or simply so that a factual issue can be determined which can give direction to the rest of the case, in particular to obviate a parcel of evidence. The purpose is to determine the fate of the plaintiff's claim or one of the claims without the cost and delays of a full trial. Paragraph 10 goes on to state that the curtailment of the duration of the trial and cutting of costs should not be the sole reason for seeking an order for a separation of the determination of the issues. In casu, the separation is sought only because of the time it may take for the first respondent to present her case. In particular, her 6 claims against the trust. There can be no saving of time and costs in a situation where the hearing of a matter takes place over 2 or more different occasions. It is even more undesirable to grant the separation as sought in casu in light of the acrimony between the parties. Separation of issues refused by Mbongwe J in DJMF and another versus LF and others, Pretoria High Court, Safely reference ZAGPPHC 1315. Right, let's move on to our next judgment of JK versus JK, ZAGPJHC, south of the Yuxke 1275 on 11 December 2024. This is under the pen of Faber AJ, and you can find it in your bundle on page 42 and in your summaries on page 5. This is an application in reconvention regarding contact rights and primary residence. Now, what had happened in this matter is the applicant in reconvention sought shared residency of a minor child pending the outcome of an investigation by the family advocate after there were previous orders restricting contact with him. Now, the parties agreed on drafts, and this is why the application in reconvention is relevant, save for 3 issues. There was previous proceedings before Windell J, and the question was whether the previous order should remain in force or be discharged, the costs of those proceedings, and the costs for the current proceedings. What was dealt with in this judgment, obviously, is the issue of previous orders and whether those orders remain in force in the face of new applications which were launched. The investigation by the family advocate was discussed, and then also costs when it comes to unreasonable conduct. In this instance, the draft order, which was agreed to by the parties, was made an order of court. The Windell J proceedings were set aside, husband to pay the costs of the current proceedings, and then no order to costs for the Windell J proceedings. A notable quote in this judgment, paragraph 15, the husband's counter application was entirely misconceived. There was no prospect that it would be heard without a forensic investigation by the family advocate. The wife's attorneys pointed this out to the husband's attorneys. He nonetheless persisted with the application. In so doing, the husband, in my judgment, acted unreasonably. In the result, I'm of the view that the wasted costs arising from the hearings during the week commencing on 2 December 2024 are to be paid by the husband on scale B of the Uniform Rules of Court. A cautionary tale, folks, of stating down matters making significant changes to care and contact without a family advocate's report or a forensic report to which the court can be guided by. That was the matter of J.K. versus J.K. under the pen of Faber J. in the South Gauteng High Court. Making fairly good time today, folks. Next up, we have DLH versus ADH and another 2014 1167 of 2024 ZA-GPJHC 1282, and this judgment saw the light of day on 13 December 2024. The judge is Lamprecht AJ, and you can find it on bundle page 48 and summary page 6. This is a contempt of court for committal for alleged failure to comply with the terms of a settlement agreement. The applicant, who was the ex-wife, alleged that the first respondent, her ex-husband, and the second respondent, his father, were in contempt of a divorce order of February 2022 that incorporated a settlement agreement. She sought committal, suspended on condition of compliance within 14 days, coercive, in other words, contempt of court. The key disputes included outstanding medical aid contributions, payment of a lump sum, settlement of municipal arrears, etc. The respondents disputed material aspects and tendered or partially complied with some obligations. In terms of procedure, the judgment dealt with Rule 27.1, non-compliance with the rules of court. As always, in our contempt of court judgments, the court looked at the requirements for contempt a la Fakey NO versus CCII systems. It looked at the PECO principles on civil contempt and contempt of court burden of proof, and it looked at whether new matter may be introduced in a replying affidavit, and obviously the court once again stating that you cannot introduce new matter in reply unless there are exceptional circumstances which justify it. What was very interesting in this matter, folks, is the judgment does not read, if my memory serves, that the matter is dismissed. The judgment literally says no order is made on this application and the parties should bear their own costs. Now, whether this means that the application is alive and well, akin to a removal from the roll, or whether it means that the matter is indeed dismissed, is quite uncertain. But I did find it quite interesting how the court, per Lamprecht AJ, decided to formulate the order. A notable quote from this judgment is in paragraph 36 of the judgment. An applicant for committal is required to prove all elements of contempt beyond reasonable doubt. Once an applicant has proved the service and or notice of the court order to the respondent and non-compliance, the respondent, however, bears an evidentiary burden to show that its non-compliance is not willful and mala fide. A presumption exists that when the first three elements of the test for contempt have been established, that a respondent is mala fide and willful, unless the respondent is able to lead evidence sufficient to create reasonable doubt as to their existence. An inability to comply with the court order, despite best endeavors to do so, is a relevant consideration. DLH versus ADH and another contempt of court per Lamprecht AJ in the Johannesburg High Court, where no order was made on the application. Next up, and coming in right at the back in terms of part 1 of this month's roundup, is Nchiba versus Mushushu and others 2469/2023. That is ZA ECMH 91 SAFLI reference. In your bundle at page 70 and your summary in page 7. So let's start off with the facts. The matter relates to a customary marriage and recognition of a customary marriage where it was celebrated in terms of the wife's culture and not the husband's culture. The applicant, who was the wife, sought a declaratory order that she was married to the deceased, her husband, in terms of the Recognition of Customary Marriages Act. She alleged that the marriage was concluded in 2015 according to the customs of the Bele clan, being her clan. The respondent's children disputed the marriage's validity, arguing that the deceased's own Sutu customs were not followed and that close relatives were not involved. The judge looked at section 3/313 sub 1, apologies, of the Recognition Act and the requirements for a valid customary marriage. The court looked at section 1 of the Recognition Act, being the requirements or the definition of a customary marriage. And then also the court restated the principles in Tsambo versus Sengadi, the principles on presumption of marriage in long-term cohabitation. In this instance, the customary marriage between the applicant and the deceased was declared to be valid. The fifth respondent, which I believe was the Department of Home Affairs or Minister, was directed to register and endorse the customary marriage, and the respondents, except for the fifth, are liable for the costs jointly and severally. A notable quote in this matter comes from paragraph 45. I hold a view that in majority of communities, the rituals that would guide the negotiations and conclusions of customary marriage are likely to be those of the bride. I say so because the groom's family would ordinarily visit that family in order to ask for a prospective wife. They visit the bride's family with hat in hand. I am unable to think that they would dictate how that particular community or tribe should go about negotiating and concluding the marriage or lobola negotiations. It is for this reason it does not come as a surprise to me that during the lobola negotiations, marriage comes into existence in certain circumstances. I observe that whatever else takes place at the groom's home can sometimes amount to a celebration of a marriage concluded at the bride's family home. The court unpacking the cultural requirements of a customary marriage. Is it necessary to follow the husband's culture or the wife's culture? And the court finding that obviously the marriage came into being by means of following the wife's customs. That was Nchiba versus Mushushu and others, 2024 ZAEC MHC 91, 26 November 2024. And all of these serious initials staring all of us in the face in judgment citations of SAFLI. Righto, folks, that brings us to the end of part 1. We are just under halfway with the roundup for this morning. As some of you run to go quickly grab a cup of coffee or a water, please allow me to remind you that you can purchase the optional course pack where we've included summaries of the cases which we are discussing, as well as a bundle of the cases by going to thinklegal.co.za, purchasing the course pack and attending the full duration of the webinar today will get you 2 SOM or social justice CPD points. Let me remind you, folks, please, for those of you who are not yet on our WhatsApp groups, please do join us on the ThinkLegal WhatsApp groups. At present, in the family law WhatsApp group, we have just under 700 family professionals who on a daily basis share knowledge, resources, and information with one another. I will paste the links to the WhatsApp groups shortly. However, for those of you wanting to quickly jump in now while we go on with the Family Law Roundup, please go to thinklegal.co.za and you can access the WhatsApp groups from there. Right, so let's go into the second half of the Family Law Roundup, December 2024. Next up, we have MSH versus JSH, and we are quite firmly in Rule 43 territory for the next 5 judgments. The first one, MSH versus JSH, Western Cape High Court, ZAWCHC 406 is your SAFLI reference, and this comes from the pen of Lekuleni J on 29 November 2024. This is a Rule 43.6 matter dealing with the issue of adequate housing. You can find it on bundle page 88 and summary page 8 for those of you following along. The applicant brought an urgent application in terms of Rule 43.6 to vary a Rule 43 order which was granted all the way back in 2019. The maintenance order was granted by the previous court, and that order obliged him to pay the mortgage bond, levies, rates, water, electricity, internet, etc. at the former matrimonial home, which was occupied by the respondent and the minor children. In July 2024, the applicant unilaterally sold this property without making any provisions for alternative accommodation for the family. The applicant then sought a new order that he pay a fixed rental allowance instead, so that the respondent and the children would vacate the property. So in this instance, Rule 43.6 was considered, and then the principles enunciated in Dutoy versus Dutoy. Obviously, in cases of this nature, the best interest of the child principle came to the fore quite significantly. Obviously, Section 28(2) of the Constitution, Section 9 of the Children's Act, etc. Now, the Rule 43.6 order was granted, but it was granted with a bit of a tail. The court imposed certain safeguards to ensure that there would be adequate provision for housing for the respondent and the children. The applicant was also ordered to pay the costs of the application. A notable quote from this judgment, folks, can be found in paragraph 37, dealing with the nature of children in a society, and the court says at paragraph 37 that children are regarded as wards of society, and it is an inherent responsibility of society to ensure their protection and well-being. Importantly, the Bill of Rights in the South African Constitution is renowned for its extensive commitment to the protection of the rights of children in Section 28(2). which emphatically underscores the paramountcy of the child's best interests. Section 6.2a of the Children's Act provides that in all proceedings, actions, or decisions in a matter concerning a child must respect, protect, promote, and fulfill the child's rights set out in the Bill of Rights, and must respect the child's inherent dignity. Very, very interesting way that Lekuleni J sets out very beautifully the status of children in a society and the way that the South African law looks at children. I really particularly like this term that the court uses as wards of society, which is quite a nice descriptive term in my view on children and how children should be dealt with in judicial and administrative proceedings to guide the approach. That was MSH versus JSH, Western Cape High Court, ZAW CHC 406, under the pen of Lekuleni J. Moving all the way back to Gauteng, we go to the North Gauteng High Court next, which is JHM versus LEM, ZA GPP HC 1277 being our Safley reference. The judge in this instance was Oosthuizen Senekal AJ, and you can find it in your bundles on page 104 and in your summaries at page 9. This is a Rule 43.6 judgment where the court looked at an application from the applicant to retrospectively vary his cash maintenance contributions based on the fact that the respondent, who was the wife in this instance, had increased her earnings. The respondent opposed this, stating that she was on a probationary contract at her new job and that her increased income was unstable. So the court in this instance was seized with deciding whether a probationary role which was unstable should be taken into account in respect of alleged increase means for the purposes of a change in circumstances, as we know is the requirement in Rule 43.6. Obviously, in this case, Rule 43.6 was expounded upon by the court. The court looked at the S versus S principles on interpretation of Rule 43 and the broad interpretation thereof. It looked at the factors on contributions to legal costs, and it looked at the carry versus carry principles on financial vulnerability of the weaker spouse. In terms of this issue, Rule 43.6, in terms of the maintenance issues, was dismissed. There was a variation regarding contact with the minor children, and costs were to stand over for later determination. Paragraph 11 and 12 are our notable quotes from the judgment. Paragraph 11 says Rule 43.6 is interpreted strictly requiring the applicant to demonstrate a material change in circumstances. It does not permit a rehearing, review, or appeal of an existing order under the pretense of a Rule 43.6 application. While the Constitutional Court in S versus S and another emphasized that Rule 43 should be interpreted broadly to ensure fairness and access to justice, it did not dispense with the requirement for an applicant in Rule 43.6 to show a material change in circumstances. This remains a fundamental prerequisite. So change in circumstances remains a fundamental prerequisite, notwithstanding the Constitutional Court in S versus S and another. That was JHM versus LEM, ZAGPPHC 1277, certainly worth a read on change in circumstances. Next up, we go to the Northwest High Court in Mahikeng under the pen of Wessels AJ, and this is the matter of RC versus MC ZANWHC 302. In this instance, the matter deals with the restoration of parental responsibilities and rights of the primary caregiver. It deals with contact with children and investigation by the Office of the Family Advocate. The applicant brought an urgent Rule 43.6 application requesting restoration of their parental rights and to remain primary caregiver pending an investigation by the family advocate and contact under the supervision of a social worker. The court had dismissed the applicant's initial Rule 43 application after the respondent removed the minor children from the matrimonial home. The applicant, dissatisfied with the outcome of the Rule 43, launched an urgent Rule 43.6, requesting that the court reconsider its decision. The application obviously dismissed with costs on scale B. The court in this instance looked at the prerequisites of Rule 43.6. It looked at the S versus S principles once again, and then under Rule 612, the issues of urgency. Paragraph 15 of the judgment deals with the issue of appealability of a Rule 43 order, and obviously whether this Rule 43.6 doesn't simply constitute an appeal dressed as a Rule 43.6. Paragraph 15 of the judgment, our notable quote, says the issue of appealability of a Rule 43 order served before the Constitutional Court in S versus S. To this extent, the constitutionality of Section 16.3 of the Superior Courts Act had to be decided. Now, paragraph 43 of the judgment, the Constitutional Court found as follows. The question is whether Section 16.3, by denying disgruntled Rule 43 litigants the right to appeal, bears a rational connection to a legitimate statutory purpose. The purpose of Rule 43 is to provide a speedy and inexpensive remedy, primarily for the benefit of women and children. The rationale for the non-appealability is to prevent delays and curtail costs. To allow an appeal process would contradict the objective of Rule 43 orders. The statutory differentiation between those litigants who can appeal and those who are precluded from doing so by Section 16.3 clearly bears a rational connection to a legitimate government purpose. And that was RC versus MC in respect of a Rule 43.6 application. Next up, we go on to CLK versus KKK, also before Faber AJ in the Johannesburg High Court. Our Safley reference in this judgment, ZAGPJHC 1287, and the judgment coming out on 17 December 2024. Bundle page 133, summary page 10 for those of you following along. In this instance, the father launched a Rule 43 which dealt with parental responsibilities and rights. Mother then went and launched a counter application for maintenance pendente lite of 42,000 Rand per month, rear maintenance of 465K, and a contribution to legal costs of 830K plus some ancillary relief. The father's application, now this was the Rule 43 in the main, this was suspended pending the outcome of investigations which had been commenced into the best interest of the children. So this matter, CLK versus KKK, is just the hearing of the mother's counter application, in other words, the financial aspects of the Rule 43 proceedings. The matters discussed, obviously, financial positions of the parties and financial disclosure, arrear maintenance, and whether there was sufficient evidence for an arrear maintenance claim, and then the issue of cell phone bill reimbursement. In this instance, a Rule 43 was granted for maintenance pendente lite, 40,000 Rand per month. The applicant wanted 42, got 40. A contribution to costs of 800,000. They wanted 830, they got 800, as well as some ancillary relief. Arrear maintenance was dismissed in this instance. Paragraph 26 of the judgment deals with the issue of arrear maintenance. This was the 465,000 which the applicant sought, which says generally arrear maintenance cannot be recovered under Uniform Rule of Court 43. There is one notable exception to this, namely if monies are borrowed by a person to enable him or her to maintain themselves, a claim for arrear maintenance will be permitted. It is unquestionable that the mother was compelled to borrow monies in order to meet the monthly requirements of both her and the children. These monies will need to be repaid. However, evidence of the full extent or relating to the full extent of the mother's borrowings and how they are said to relate to the claim of 465,000 is entirely unclear. This claim has not been established. The court finding that had, or hypothetically, essentially had the wife or the mother provided proof of the loans, how it was utilized, etc., the claim may have been successful. Obviously, in this case, she did not, as found by the court, and the claim for arrear maintenance was dismissed on this basis. That was CLK versus KKK, ZAGPJ, HC1287, which was before Farber AJ. Next up, we go to ADVR versus JVR, and this matter hails once again from the South Gauteng High Court. This matter was before Khan AJ. You can find it in your bundle on page 143 and in your summary on page 11. In this instance, the applicant brought the Rule 43 for spousal maintenance pendente lite of 30,000 per month, contribution to costs of 519,000 and ancillaries. The applicant, who is a homemaker, launched the Rule 43 based on financial insecurity caused by the respondent by making inconsistent maintenance contributions and supporting his current girlfriend. The respondent obviously pleaded poverty, claiming that his investments and his income is largely dependent on investments and royalties, and that his monthly salary has decreased, which forced him to prioritize payments over that of the applicant. The court considered the principles in tort versus tort regarding maintenance pendente lite and standard of living, and carry versus carry principles on contribution to costs. So in this instance, Rule 43 order was granted. Maintenance of 20,000 per month was ordered. The applicant sought 30, got 20. The applicant was given a contribution to costs of 50,000, which is a far cry from the 519,000, which was sought in terms of Rule 43. Respondent was ordered to pay the party and party costs of the application on scale A. Paragraph 34 of this Rule 43 judgment is our notable quote from this judgment. The quantum of maintenance payable must, in the final result, depend upon a reasonable interpretation of the summarized facts contained in the founding and answering affidavits, as indeed is contemplated and intended by Rule 43. It is also, in my view, helpful to take cognizance of the approach made in the affidavits by the applicant and the respondent respectively, bearing in mind that normally it is not the practice in these matters, although permissible, to test the evidence viva voce. A claim supported by reasonable and moderate detail carries more weight than one which includes extravagant and extortionate demands. Similarly, more weight will be attached to the affidavits of a respondent who evinces a willingness to implement his lawful obligations than one who is obviously, albeit on paper, seeking to evade them. This obviously drawing on our classical established Rule 43 cases. This was ADVR versus JVR under the pen of Khan AJ in the South Gauteng High Court. Folks, I see we've got a very quiet comment section this morning. I think everyone's probably still reeling from getting back into the swing of things early in January this year. But for those of you who have found any of the cases so far to be interesting or noteworthy, or you have particular views on any of the cases, please do share them with me in the comments, the chat on StreamYard, comments on YouTube, and comments on LinkedIn and Facebook while the stream goes on. Geraldine letting me know that you guys are here. Thank you, Geraldine. I appreciate that. Right, now that I've managed to just take a deep breath and get my vocal cords a little bit rested, let's go on to our next judgment. If I can get my iPad to cooperate. Let's see. There we go. Oh, thank goodness. That was nerve-wracking. Say what you will about pen and paper, it won't give you an error 404 out of nowhere. Right, let's go on to our next judgment. SLM versus FRRM. Once again, a judgment by Faber AJ in the South Gauteng High Court. Your SAFLI citation, folks, is ZAGP JHC 1285 and bundle page 160, summary page 12. We are now in the realm of matters dealing with minor children, and obviously we should see what we're going to be going through that lens. This was an urgent application for the variation of what is referred to in the judgment as a consent paper. The applicant brought an urgent application for variation of the consent paper regarding primary residence of the minor children. The parties, in their divorce action with a consent paper that was made in order of court, agreed that the children's primary residence would be awarded to the mother, the applicant, and that both parties would share full PRR, with the respondent, the father, having extensive contact with the children. The applicant secured employment and accommodation and schooling for the children in Cape Town and relocated. The children remained with the respondent, the father, in terms of an interim agreement between the parties, with this underlying understanding between the parties that the children would join her in Cape Town at the end of the year. The respondent, some may argue, changed his mind. Some might say that there was never a meeting of the minds, but the respondent then took the stance come time of moving the children to Cape Town, that a firm decision had not yet been made, and that the status quo should not be disrupted. The applicant then launched the urgent application to vary the consent paper, and the respondent then opposed the application. Obviously, in such an instance, the court has to deal with evidence and versions, and when there are conflicting evidence and insufficient, or conflicting versions and insufficient evidence, the court is at a loss to the order that it needs to make. And that is exactly what happened in this instance. There were conflicting versions on the papers, and there was simply insufficient evidence for the court to determine the matter. An order was agreed to between the parties on the future of the conduct of the matter, save for one or two issues. So the order was then made on the future conduct of the matter, and the draft order was made an order of court. The respondent was ordered to pay the costs. A notable quote on paragraph 10 of the judgment, the court states, "I cannot resolve the conflicting versions of the mother and father in relation to a move to Cape Town and the circumstances under which that occurred. I consequently need to independently determine whether the best interest of the child will be served should they relocate to Cape Town and assume permanent residence with their mother in that city. I, at present, do not have sufficient evidential material to responsibly make that determination." I like the wording of the judgment, to responsibly make that determination. I cannot make that determination bearing in mind my responsibility to the minor children and the parties. This was SLM versus FRRM, emanating from the South Gauteng High Court under the pen of Faber AJ, and this SAFLI reference ZAGPJHC 1285. In these types of matters where relocations are involved, it is critical to go to court armed with an expert report. Next up, we have two judgments that go together. Both emanated from the North Gauteng High Court under the pen of Millard J. in December 2024. I put these two judgments together because it is just convenient to do so. It's a very complex matter, a very tragic matter, in fact, and it does make more sense to deal with both of the judgments together. So the first one we will be dealing with is the first judgment on the merits, shall we say that. And then secondly, we will be looking at the leave to execute the terms of the order pending an appeal. As I mentioned, the judge is Millard J. First judgment is CJW and another versus SJP and others, ZAGP PHC 1217, bundle page 164 and summary page 13. This was an application for the removal of guardianship and primary care and residence. Now, what you will note from this matter, folks, is that we are dealing with extended family in this matter. The parents of the minor child had both passed, and there was an appointment of guardians. In the father, I believe, was the last passing of the parties. There was an assignment of guardianship in his will. So the applicant brought an application in terms of Section 24(3) of the Children's Act for the removal of the respondent as the guardian of the minor children, and then for the applicant to be replaced as guardian. So the respondent to be removed as guardian and the applicant to be installed as guardian. Further, the issue was raised whether the minor children should retain their primary residence and primary care with the respondent, or whether it should be transferred to the applicants. A very interesting judgment, this quite a lengthy judgment if my memory serves from preparing it. We go from page 164 to 209, so it's about a 45-page judgment dealing with Section 24(3) of the Children's Act. Investigations and reports by the curatrix and clinical psychologists was looked at. Hendricks versus Hendricks, principles on the right to cohabitation was looked at. Section 18(3) to 5 of the Children's Act, obviously dealing with guardianship, was considered. And then obviously Section 7(1) of the Children's Act being our best interests checklist. The removal of guardianship was granted. The first applicant was appointed as the guardian of the minor children. Primary care and residence of the children granted to the first and second applicants. And then cost of suit to date on the attorney and client scale to be paid by the first respondent. Notable quotes, paragraph 87 and paragraph 75. Paragraph 87 reads as follows. The court, as upper guardian, does not look at a set of circumstances in isolation. Any decision to be made must be made holistically on consideration of all of the circumstances. Next up, paragraph 75 says, a guardian, particularly when such guardian is not one of the biological parents of the minor, has a fiduciary duty to protect the assets of a minor. Very interesting judgment by Millar J. in the North Gauteng High Court. Corin saying she's enjoying the kiddies playing in the background. I absolutely agree. You would have heard a plane going overhead now as well. Once again, for those who joined us late, I am not in Johannesburg at the moment. I'm working remotely, and obviously we've got a little bit of a noise going on in the background, for which I sincerely apologize. Henri stating, let's see, one of our comments. Hi, all, I want to do a bit more research in the area relevant to Nchiba versus Mashushu and others. Let me know if you know of any other cases I should read relating to customary marriage and the use of the women's customs, or even the effect of matrimonial domicile in these cases. Some very interesting matters regarding domicile of late, Henri, and an interesting line of cases in terms of customary law over the last 12 months. You're welcome to email me should you wish. Alternatively, you are more than welcome to also pop the message on the WhatsApp groups, and I'm sure that the other members of the group would be happy to give you some information on that as well. Right, folks, so we've now dealt with CJW and another versus SJP. This was heard on the 2nd of December. An application for leave to appeal was delivered. On the 5th of December, the parties were back in court once again before Millar J. So remember, the first judgment had the effect of removing the first respondent as guardian and also taking away primary residence from the first respondent. The first respondent then files an application for leave to appeal. Now, we know an application for leave to appeal or a pending appeal suspends the operation of an order which was granted. What can happen then in terms of Section 18(1) and 3 of the Superior Courts Act is the applicant who obtained the order can approach the court for the order to be put into effect pending the outcome of an appeal. And this is exactly what happened here on the 5th of December 2024, folks. The applicant, after getting their order, having the leave to appeal served on them, approached the court that they want the order of 2 December to be put into effect immediately despite the pending appeal. The order was obviously granted in light of the fact that the pending appeal would suspend the operation of the order. The court looked at Section 18(1) and 3 of the Superior Courts Acts requirements. Specifically, it honed in on exceptional circumstances and irreparable harm, And obviously, as is the case in these types of matters, the court looked at the best interests of the child, which is obviously our paramount consideration in terms of Section 28(2) of the Constitution and Section 9 of the Children's Act. Now, what happened in this application for leave to enforce the terms of the order pending the appeal is that the application was granted. The applicant was permitted to proceed in terms of the order which was granted pending the appeal, and the first respondent was ordered to pay the cost of the application on an attorney and client scale, no less. Our notable quote in this matter, with our noise in the background, if you'll forgive me, our notable quote, paragraph 18, put simply, in the circumstances of this case, it is not whether the litigants will suffer irreparable harm, but whether the minor children who are the subject of the litigation will suffer irreparable harm. In all matters involving children, it is trite that their interests are to be preferred above all else. The court then finding that the children would suffer irreparable harm if the order was not put into force immediately pending the appeal. So two very interesting matters finding their way to the North Gauteng High Court in the court of Millar J in December of 2024. Now, folks, bringing us to our final judgment of the Family Law Roundup, December 2024, is the matter of TWR versus QET. This is an appeal matter in respect of a domestic violence order which was granted. Our quorum in this matter was Van der Schuyf J and Mazibuko AJ. The judgment drafted by Mazibuko AJ with Van der Schuyf J concurring. Full citation is TWR versus QET, and this is from the North Gauteng High Court with Safley reference ZAGBP HC1319. We are on page 220 of our bundle and page 14 of our summary. This relates to an appeal from a domestic violence final domestic violence order from the domestic violence court. The appellant appealed against the judgment of the court a quo, where the final order was issued against them. What was interesting about the domestic violence proceedings was the court struck out the applicant in that instance, not the appellant, the applicant in the domestic violence proceedings. The court struck out their replying affidavit. Nevertheless, after striking out the replying affidavit, a domestic violence order was granted. The appellant then requested reasons for the judgment in terms of Rule 51, and the magistrate provided reasons in terms of Rule 51. When providing the reasons, the magistrate referred to the applicant's replying affidavit, which was previously struck out. In prosecuting the appeal, the point was taken that the magistrate clearly erred, because you cannot strike out an affidavit, make it pro non scripto, and then still refer to it in your reasons for judgment or take into account that affidavit when formulating your judgment. The appeal was upheld. The court a quo's order was set aside, and there was no order as to costs. The aspects in the ground covered in this judgment relates to Section 6 of the Domestic Violence Act, Rule 51(1) of the Magistrates Court Rules and the Reasons for Judgment, and Section 15 of the Domestic Violence Act dealing with the issue of costs. Now, our notable quote in this judgment runs over 3 paragraphs, paragraph 12 to 14, folks, and it reads as follows. In my respectful view, the effect of a struck out, be it the whole part of the record or the whole or part of the record, must be its non-existence in the court's mind, as if it was never filed and never formed part of the record. In casu, it meant no affidavit was filed after R's answering affidavit. Consequently, T relied on her founding affidavit only to prove her case, which means she was barred from referring to the replying affidavit and the content thereof. Such a position was not avertible to the court a quo. The disparity or disconnect between the judgment and the written reasons amounts to a misdirection, as the subsequent reasons vitiate the judgment. For these reasons alone, the appeal ought to succeed. I need not evaluate the other grounds raised by the appellant. Concerning costs, Section 15 of the Act provides that the court may only make an order as to costs against any party if it is satisfied that such party has acted frivolously, vexatiously, or unreasonably. T did not oppose the appeal. The court a quo initially found in her favor when it confirmed the interim protection order prior to its written reasons. These written reasons vitiated the judgment when the court referred to parts of pleadings that it had previously ruled against, when it upheld the point of law regarding non-compliance of the replying affidavit with the regulations, thereby precluding itself from considering it in its judgment. Consequently, I find no justification to award costs against T. So this judgment, making it very clear that the domestic violence court erred when striking out a pleading and then later on relying on the contents of the pleading when providing exposition of the status of the court. The effect is a non-existence of the document in the court's mind. That was our domestic violence judgment of TWR versus QET ZAGPPHC 1319, which came out on 10 December 2024 under the pen of Mazibuko AJ, with van der Schyff J concurring. So, folks, those were our 17 judgments in the family law roundup for December 2024. STH versus ATH, MM versus SMT, WB versus JJB, DJMF and another, JK versus JK, DLH versus ADH, and then Nchiba versus Mushushu on customary marriages, bringing up the rear in the first part of the roundup. And then part 2, MSH versus JSH, JHM versus LEM, RC versus MC, CLK versus KKK, ADVR versus JVR, SLM versus FRRM, CJW and another versus SJP, CW and another versus SP, and then last but certainly not least, TWR versus QET. A lot of very interesting abbreviations that I need to go through once per month. From my side, I want to thank all of you for taking the time to attend the Family Law Roundup, December 2024, with me, Mervyn Vermeulen. Special word of thanks to Atligang Messi, my candidate attorney, who assists me in compiling and summarizing the cases for all of your assistance. Melissa asking me to show part 1 again. Melissa, there you go. You're welcome to have a look at it. And then also, obviously, very, very special thanks to the organizations that assist us: Lawbox Practice Management Software by lawyers, for lawyers, try Lawbox free, 14 days, lawbox.co.za, and the patience of my colleagues at Vermeulen Attorneys, now also operating in Ballito in the North Coast. Please do support us if you are inclined to do so by purchasing the course pack. 250 Rand gets you the summaries and the bundle of case law. For those of you who would like to join our WhatsApp groups or view some of our past webinars, please go to thinklegal.co.za. My reminder of our upcoming 2 webinars in the next month. First off, we have next week's Agile Assertiveness with Louis Nachrini, which is a must attend, in my view, for lawyers and mediators, and will be of certainly great value to our mental health professionals as well, where Louis teaches us to say what we mean and mean what we say without being mean. Very, very entertaining and insightful speaker, Mr. Louis Nachrini, joining us next week, Friday, for that free session on the platform, 9 o'clock to 11 o'clock next week, Friday. And then our opportunity to also chime in on this very interesting discussion relating to artificial intelligence in the practice of law and professional fields, which we've called AI Literacy, a Legal Perspective, on 28th of February 2025. The rest of our calendar will be advised as and when topics become available. So from my side, friends and colleagues, thank you for joining me, coming to you all the way from the South Coast, where it is gloomy but sweltering. I look forward to seeing all of you back in WhatsApp land, and I will be ending the stream until next week, when I will see you for our next session with Louis. Thank you again for attending, and I will end the stream in 5, 4, 3, 2, 1. Have a great weekend, everyone.